Good afternoon. At present, registrants face a long list of requirements to have a domain delegated to their name, redelegated, to cancel it, to suspend it, and so on. Certain claims are made by different parties, which become parties to a dispute. I would try to be very brief and to focus your attention on the most problematic issues. So we will look at the least standard situations where you need to be creative and which you need to resolve successfully. The first thing that everyone is confronted with once they enter the domain market is the requests they receive. We subdivided them into several areas. Requests or inquiries from lawyers is probably the largest part of these inquiries. Then the second part is inquiries from courts of general jurisdiction, including criminal and civil, and commercial courts as well. The third group would be inquiries coming from law enforcement offices. And then the fourth type is miscellaneous. That would include governmental agencies as well as other agencies and persons. We have done this analysis for 2015 and 2016. We can see that inquiries from lawyers more than half, 54% of all claims and inquiries that registrants receive. They have increased by 48% compared with the previous years, and the second group is 21%. These are the claims and inquiries coming from courts. 6% come from governmental bodies, and then what we dubbed others. The main request has to do with the request for information of who is the registrant. The smaller group would be a request to perform certain actions. A more detailed presentation on the same topic was done at the previous conference, and those of you who are interested can go back and look at it. As for the request to perform certain actions, the registrant is free to turn them down with the exception of one type only. When the request comes from the court system, then the registrant has no right to decline this request because this is a mandatory request. Then my next slide describes a situation which is not very common. A request that comes from a foreign court. In this particular instance, it comes from a United States District Court, and it is called a temporary restraining order. We can see that a court order was made to transfer a certain domain name from the current registrant to a different registrant. This was sent by a SAC representative, and which is a body that helps execute court orders. So They received this document, and it remains valid in many jurisdictions. And in the event of failure to respond, this goes to the chief administrator of the top-level domains. Although this is a fully official document that contains all the necessary information about its source, despite that, I must say that in Ukraine, you do not really have to obey it. Even though the procedure is there, we are operating under the Ukrainian law. So whenever we receive court orders from other countries, they need to be validated by our national court system, and they need to cover our jurisdiction. Other than that, the document, the paper, has no value under the Section 8 of the Ukrainian Civil Code, and there is no need to act. Another similar example, I believe many of you have had experience of dealing with some cases from Russia with similar restraining orders prohibiting dissemination of certain information on the internet. Again, the procedure is there because the Russian domain market is larger. The procedure is somewhat different from ours, and in this particular case, you are invited to participate in the litigation involving the domain owner and the domain registrant. However, the final court order here will not necessarily be based on this document, and the information you are prohibited from distributing has to be legal by the Ukrainian law, not just by the Russian law. A short review of court cases in 2014, 2015, and 2016 partially, cases related to domain names. As we can see here, there are two types: civil cases and commercial cases. 18 civil cases, 9 were 5 were won, 9 were lost, and 5 were closed. 21 cases, 12 cases won, 4 cases went through arbitration and settled. The remainder were closed. Currently, 12 cases are being heard under the governmental register. The statistics are this: 7 commercial cases, including 2 cases that are currently heard by the higher commercial court. Others are handled by general jurisdiction courts, plus 1 case is being heard by the appellate court. Judging by that statistics, we cannot make any general conclusions. That would be premature. Well,
there is a number of things that have not been legally resolved yet, and we are presenting them on this slide. First, there are parameters like proof, the unsubstantiated and needless requirements, and the impossibility to fulfill them. I will now go into detail on all of them. So first off, evidence. This has to do with recording the content on a website in question. I know that the next presenter will go into detail here, but really, as of today, our legislation does not define parameters here, and so the methods for copying or recording the site, printing it out, whether it's printing it out or looking at having the court look at the site, or video or audio recording, none have been defined by the law. So it's still up to the courts. Well, then, most of the time, the cases involve requests to stop registration or stop delegation of a domain name. However, there are more unusual cases. For example, there was a case of a future registrant trying to register an already registered domain name. So the future registrant decided, even though he saw that the domain has been registered, the registrant decided to still pay for it because he thought that the registrant data was not fully presented. And the decision was made that first the registrant tried figuring it out with the registry, but in the end went to the courts. The registrant's requirements, the register, we believe they should not be taken into account because there was already an agreement in place between the other two parties, and so the decision was not made in the registrant favor. Also, domain names cannot be delegated if they have already been taken. Otherwise, it's a violation of the first registrant rights. And finally, another area to work on. We have a recent law that doesn't even have a 7-day waiting period for the court order to be executed. These days, the 7-day period is gone. You have to execute the order immediately. However, there is a 30-day period, redemption period, correct? And if at the end of that period no action was taken for domain names, 5 days after the end of the redemption period, the domain is completely stricken. And then let me look at the future of legislation in for the domain name industry. Um, the president has limited a law supported by the government that had to do with combating piracy, but it had to do with the protecting film the film industry. According to the law, the all of the parties involved were supposed to provide valid information for who is. The lack of information in who is would have let the registrant go directly to the host. And in that case, the hosting provider would have to submit the appropriate documents to the customer. And so in that sense, hosting providers would have had to provide the relevant documents and would then stop the publication of those of pirated content, for example. Essentially, this has to do with establishing the person to be addressed in case of rights violations, right? This is an algorithm that was provided for resolving these types of issues. If you could, how long does a case last, and how often is there settlement? Well, like I was saying earlier, well, obviously, these last longer, longer than what's defined by the courts, right? So there is no quick solution. And are there more cases of voluntary actions as opposed to orders, right? There were just 4 settlements in commercials and a civil in 1, right? So out of 18, these are lower low numbers. For civil cases, there was 1 case dropped. But essentially, settlements aren't the prevailing method for resolving domain name disputes, even if there is a court involved. And finally, how do the lawyers evaluate evidence? How easy is it to make sure there is evidence in place? What proof can exist that content was in fact posted and published online? For a for a judge, a printout is enough provided by the sides. There is also the preponderance of evidence approach, which states that essentially it's more likely to be this way than this other way. How deep down do the courts drill? Well, for the courts, the requirements are rather strict, and what you just mentioned here, this does not exist, and which is why what we just presented here is problematic. So because there is no clear definition, a a certificate signed by a appropriate agency, nothing like that exists. So it's up to the court to decide as to the validity of the evidence presented by either side or even a third party. Thank you.